Hey folks, welcome to another episode of the Preparedness Podcast, the podcast that brings you the best in preparedness information. My name is Rob Hannes, and I am the host for the show. You can get to the website at thepreparednesspodcast.com, and you can email me at rob@prepcast.info. This is going to be a slightly different podcast from normal in that it's probably going to be short and it's going to be very specific. But I thought it'd be interesting to talk about a news article that I tweeted out earlier today, and today being October 10th, 2012. It's an article in the New York Sun. I'll have the link in the show notes. And I do this because typically links are very long, and it's just easier to go to the website and just click on a link than it is to try to copy down what I say. So that's why I put it in the show notes. The name of the article is Legal Tender Next, and I'm going to read the article, not necessarily word for word. I'm going to kind of paraphrase it because you can read it yourself, and I'm going to kind of explain what some of the significances are, and not because I'm an expert on this type of law or anything like that, but because some of the things that the way they write it can be explained a little bit easier. I was actually having a conversation with my wife about this today because I'm kind of excited that this is actually out in mainstream now. Well, okay, maybe not mainstream because it's really not being talked about that much as far as I can tell. However, this is very real, and it's dealing with what constitutional money is, the legal constitutional definition of money. So this is about a case called Beer versus United States. The plaintiffs are Judge Peter Beer and some judges on the federal bench. They have just won a ruling that prohibits Congress from suspending a system of automatic pay increases that are designed to protect against inflation, much like Social Security is. Now, the United States Court of Appeals for the Federal Circuit Court, or the Federal Circuit, handed down a ruling on Friday, which would be the 5th of October of 2012. The ruling hasn't received much coverage in the press, though in our view, as the New York Sun is writing, and in my view personally, I think this is one of the most important cases of our time. The reason is because it doesn't so much have to do with the question for Congress keeping their promises as it does attracting attention to the question of constitutional money. Now, I actually remember learning this back in high school, and I completely forgot until I had read this article. But judges are protected under the Constitution so that you can never, ever take away their pay. You cannot diminish their pay. You cannot hold their pay or their salary at bay or put any restrictions on it in any regard. And that is so that they are not bound to anybody else's will. Our founders did this because George III made all the judges dependent on his will, because if they didn't do what he wanted, then they didn't have a job or they didn't get paid or paid as much. So our founding fathers wrote it into the into the Constitution, that the compensation of judges shall not be diminished during their term in office. Now, in this Beer versus the United States, the judges sued under that clause after Congress had suspended the automatic pay increases that it had established to protect their honors from inflation. What the appeals court just ruled is that Congress, in suspending the automatic pay increases, diminished the judges' pay, particularly because when Congress legislated the automatic pay increases, it also established limits on the outside income that judges are permitted to earn. So in other words, Congress said, we are going to pay you X number of dollars, and we are never going to take away this pay. Plus, we are going to have an automatic pay increase that is adjusted for inflation so that your pay is always commensurate with, the standard of inflation and what things are valued. However, because we're going to do this, you are not allowed to make income on the side doing certain things. And I don't really know what that is right now, but basically it's like if you were a painter and you got a a government job painting buildings, and they said, okay, you have basically a job for life. We're going to pay you X amount of dollars, and you are going to get paid this every year. And as inflation increases, you will automatically get a pay increase that is equal to the inflation, so that you never have to worry about your pay being diminished or being able to not afford the same things that you always afford. So, however, because of that, and for that compensation, you cannot go out and paint other people's houses unless they're like for charity or for a good cause or something like that. You have stipulations on how you can make money on the side. Continuing on with the article, it says more broadly, at least by our lights, the ruling says in effect that the legal tender laws don't apply to judges' salaries. That is, the court is suggesting that in at least the case of these judges, $100,000 bills will not be sufficient in 2012 for a contract to pay $100,000 if it was entered into 12 years ago. The appeals court packed its opinion with some language from the founding era. Okay, so what they're saying is, they're saying that there has to be a standard against which the dollar is measured. For example, in the year 2000, if you're paid $100,000 and that $100,000 would buy, let's just say, 100 bushels of cherries, that's the standard. Whatever 100 bushels of cherries buys, that's what your pay is. Well, 12 years later, you don't pay me $100,000 12 years later. You pay me whatever 100 bushels of cherries would cost. That's what my pay is, because that's what my standard is. Again, it doesn't matter whether it's gold or silver or another currency or wheat or cherries or whatever. It's a standard. And what this ruling is saying is that no, $100,000 is not the same 12 years ago for a contract that was entered in the past. You have to pay us in the equivalent standard amount. Okay, they even used some language from the Federalist Papers, and they even basically talked about James Madison and how he urged that the money could be standardized against wheat or something of other permanent value, and whereas the wheat was rejected, basically the Constitution does acknowledge that the fluctuations of the value of money needs to be addressed. So here's where I think it gets really interesting. It turns out that the historical record is very clear on what the Founding Fathers thought dollars were. According to this article I'm reading, they used the word dollars twice in the Constitution. By a dollar, they meant 371 1/4 grains of pure silver, or a 15th as many grains of gold. That's the way Congress defined a dollar in law under the Articles of Confederation, and the way Congress defined it in law in the first Coinage Act of the constitutional era. In other words, what they're saying is the dollar, as defined very specifically by the Coinage Act of 1792, is defined very specifically as being equal to 371 1/4 grains of pure silver, or 1/15 as much as that in gold. It's an actual legal definition of how much our dollar is supposed to be valued at. The idea that a dollar could be worth a different number of grains of silver or gold at the end of a contract than it meant at the beginning of the contract would have horrified George Washington and nearly all the other founders. So would the idea that the dollar would be permitted to decline over a decade, but to a sixth of the number of grains of gold at which it was valued at the start of the decade. And this is what has just happened in America. And what they're saying here is that in the last decade or so, your dollar has lost so much value that it's only worth 1/6 of what it was worth a decade ago. Continuing, the court deciding Beard didn't get into legal tender per se, but the legal tender question is the elephant in the courtroom. In other words, if the dollar cannot be diminished for judges, that is, if the legal tender laws are not good enough for judges, why should they be good enough for the rest of us? And that's the question I think is paramount. If they're not good enough for a contract between the government and judges, why should they be good enough for contracts between you and me? Now, don't think that this is simply the judges getting all bent out of shape because they're not getting paid enough. We want our judges to be able to make a good living at what they do, to be honest men and women, because they are the men and women who help control our laws. We need the judicial branch. It has to be an honorable set of people. And if you basically inflate them or diminish their pay into poverty, then that makes them susceptible to bribes and other corruption, and we don't want that. As a matter of fact, according to this article, the chief justices of the Supreme Court have been warning about this for quite a while. So, to me, this is definitely an article I'm going to be trying to follow. Hopefully, it won't get swept under the carpet like a lot of articles get. I saw this come through an email from Jim Sinclair in his JS Mindset newsletter, and I thought it was immediately interesting, and I tweeted it out. It's so important that I thought it would be enough to put out a short, quick podcast on, just to bring the attention of this to as many people as possible, because I think it is important that we need to basically say, hey, yeah, what about this legal tender that's in the Constitution? Shouldn't we be following that? I mean, instead of going to debt and printing money out of thin air and going from 16 trillion to 32 trillion debt that we can't pay ever, and basically, hawking the future of all our children, let's get back to this notion of what real money is, and let's try to fix our country. For the Preparedness Podcast, my name is Rob Hannes. You can find us online at thepreparednesspodcast.com, or you can email me directly at rob@prepcast.info. This has just been a real quick podcast. I hope you either learned something or I hope you found it interesting. Until next time, enjoy life and be safe.